Here is something the collector calling you will never mention. On an old enough debt, they can be the one breaking the law, and the same law lets you hold them accountable for it. Because once a debt passes a certain age, trying to sue you over it is itself illegal, and the same law that protects you lets you hold the collector accountable in court, up to $1,000 in statutory damages per lawsuit. Start with the clock. Every state puts a time limit on how long a collector has to take you to court over a debt. It is called the statute of limitations, and in most states it runs 3 to 6 years. When that window closes, the debt becomes time-barred. And under a federal rule called Regulation F, a collector cannot sue you on it, and cannot even threaten to. It does not matter if they claim they did not know. The law holds them responsible anyway. But be careful what time-barred does not mean. It does not erase the debt. They can still ask you to pay, and it can still sit on your credit report for up to 7 years. Those are two completely different clocks. So how do you find your clock? It depends on your state, the type of debt, and usually the date of your last payment or activity. Look up your state's statute of limitations before you say a single word to a collector. This old, time-barred debt has a name: zombie debt. It gets bought for pennies, sold from one collector to the next, and then it comes back to life. A brand new company calling about a balance you thought was long dead. And here is the trap from the earlier video, in one line. On a time-barred debt, a single payment, or even confirming it is yours, can restart the clock and revive a lawsuit they were barred from filing. So until you have verified all of it, give them nothing, not $1, not one word. Now, the part almost no one uses. The Fair Debt Collection Practices Act does not just limit collectors. Section 1692K lets you take them to court and hold them accountable when they break it. Win, and the court can award up to $1,000 in statutory damages per lawsuit, even if the violation never cost you a cent. On top of that, any actual losses you suffered, plus your attorney fees and court costs. This is accountability for breaking the law, not a payday to chase. So what counts as a violation? Calling before 8 a.m. or after 9 p.m. Threats or harassment. Lying about who they are or how much you owe. Suing or even threatening to sue. On time barred debt. Or ignoring a dispute you sent them in writing. And because the law forces the collector to pay your attorney fees, many consumer lawyers take these cases for free up front. You pay only if you win. You don't always need a lawyer. For a clear violation, many people file in small claims court. It is faster, cheaper, and built for regular people. Just know that small claims usually caps how much you can win. But a case is only as strong as your evidence. Save everything. Call dates and times, voicemails, every letter, and the certified mail receipts from the letters we sent in the earlier videos. That paper trail is your case. One warning about timing, and this clock is on you. You have just 1 year from the date of the violation to file. Miss it, and the right to sue is gone. So the day it happens, write it down. Look at how far this has come. 4 videos ago, a ringing phone felt like a threat. Now you know the collector can be the one breaking the law and the one held accountable for it. None of this is about escaping a debt you genuinely owe. It is about not being bullied, tricked, or sued by someone who broke the rules. But even a dead debt may still be sitting on your credit report. That is the next fight, and where this series turns from the phone call to the credit bureaus themselves.